Testing. Good evening and welcome to this special session of the Kansas Supreme Court. There are still some people filing in, but I have a couple introductory remarks before we have the session today. My name is Doug Shima and I'm clerk of the Kansas Supreme Court, and you guys are in for a special session today. And the best thing about tonight is what's going to happen afterwards also, is that all of the justices will be out there for a reception after this event. This is a unique opportunity for you to meet every single one of the Kansas Supreme Court justices if you want. They'll be there. They'll be willing to talk to you. They'll answer any questions, hopefully. And it's a great opportunity for you to meet them and meet them in person. And so I encourage you to stay after for the reception and take advantage of that opportunity. The most important warning I have for you tonight, though, is your cell phones. Please make sure they are completely powered off for tonight's transmission. We are recording tonight. We're live streaming it. We're going to put it on the web. And so if you want to go back and for whatever reason watch this again, you can, because it'll be archived on the Kansas Supreme Court website. So you'll be able to see everything again tonight. So turn your cell phones off. You don't want them to go off, and enjoy the proceedings for tonight. One thing, when the bailiff calls and says, "All rise, please everybody rise," when the court comes into session, at that point, then the chief will take over the proceedings and he will let you know when you can be seated. I'm honored to introduce Chief Judge Kevin Behrens, who oversees the 15th Judicial District here in Northwest Kansas. He oversees 7 counties, so he's a very busy judge. And he's going to give you a little bit of summary. I know you have it in the pamphlets today. He's going to give a little bit more perspective on the cases you're going to hear tonight. So please help me welcome Judge Kevin Behrens.
Thank you very much. Thank you, Mr. Shima, for that introduction. I want to welcome you. Tonight's cases are State of Kansas versus Daniel Bartlett. Bartlett's cousin was shot and killed a person by the name of Chad Ford. Bartlett was charged with aiding and abetting felony murder and criminal discharge of a firearm. The jury convicted Mr. Bartlett of the latter offense, or the criminal discharge of a firearm. The Court of Appeals affirmed the convictions after he had later pled guilty to voluntary manslaughter. The issues which are going to be the center of tonight's appeal is that whether the jury instructions given by the trial judge were proper, whether the district court's refusal to declare a mistrial was appropriate, and whether Bartlett received a fair trial. The other case that will be on the docket this evening is a civil case. It's LCL LLC plaintiffs versus James W. Phelan in his capacity as sole trustee of the James W. Phelan Living Trust UA, dated April 30, 2007. Julia D. Phelan, Gregory A. Phelan, and Merrill M. Weskolowski versus Rice County Abstract and Title Company, Inc. The Phelans sold real estate in 2008, but retained what is called a mineral interest. The contract reflected the reservation of the mineral interest, but the deed that was transferring the property did not. When the property was sold later in 2014 to LCL, the deed again did not reflect the reservation of the mineral interest by the prior owners. When it was discovered by Rice County Abstract Title Company, they asked LCL to deed over the mineral interest back over to the Phelans. Instead, LCL claimed an interest in the ownership of the mineral interests. The Phelans then sued Rice County Abstract and Title for breach of implied contract and fiduciary duty. The district court ruled that the Rice County Abstract and Title in their favor because the statute of limitations expired. The Court of Appeals ruled that the Phelans could pursue the claims of negligence and breach of fiduciary duty against the title company. The issues then focus on the application of the statute of limitations.
Thank you, Judge Behrens. We'll be in session when the court comes. Again, please rise when the court comes into session, and we'll be ready to go. It's okay to talk if you want now.
Would you all please rise? The Honorable Justices of the Supreme Court of the State of Kansas. Hear ye, hear ye, hear ye. All persons having business before this honorable court are admonished to draw nigh and give their attention to the court now sitting.
Seated. Good evening. Welcome to this special session of the Kansas Supreme Court. We're pleased to be holding it in the auditorium of Colby High School. Since 2011, we have tried to make our court more accessible to the nearly 3 million Kansans that we serve by seeing firsthand who we are, what we do, and how we do it. In that way, Kansans learn more about how their court system functions and also the role of the judiciary. For example, tonight, we will not do a public opinion survey or ask you to tell us how you think that we should decide these cases, but we will ask the attorneys questions to help us do our job, which is to interpret the law and make the decision that the law requires, and not based on our personal beliefs or because of politics or because of special interests. We strive to maintain fair and impartial courts for all Kansans, for as a man named Thomas Jefferson once said, the most sacred of the duties of a government is to do equal and impartial justice for all its citizens. This is the Supreme Court's first visit to Colby in the court's 157-year history, and it is only the 8th time in history that the court has heard cases in the evening. We have held special sessions in my hometown of Salina, Greensburg, Overland Park, Wichita, Pittsburgh, Kansas City, Hayes, Garden City, Topeka, Hiawatha, Hutchinson, Winfield, and Emporia. To paraphrase an old Beach Boys song that Justice Johnson likes to sing, we get around. Speaking of my colleague, I would now like to introduce my colleagues who are sitting with me on the bench this evening. I'll introduce them in order of seniority, by name, and also their hometown. To my right, this is our Senior Associate Justice. This is Justice Marla Lukert. Her hometown is from Goodland, Kansas, USA.
Go Cowboys.
Can you say that here?
Of course, Goodland is on the western border, on the opposite border from Kansas City, Kansas. To my left, this is Justice Carol Beyer, Kansas City, Kansas. To Justice Lukert's right, this is Justice Eric Rosen, hometown Topeka. To Justice Beyer's left, this is the Justice Lee Johnson from Caldwell, Kansas, on our southern border. To the far right, this is Justice Dan Biles, hometown El Dorado. And to my far left, this is Justice Caleb Stegall, hometown Lawrence. An activity this large takes a tremendous amount of planning, so I would like to thank publicly those who work so hard to make it a success. I want to thank Superintendent Katina Bren and Colby High School Principal Dr. Stephanie McNamara. You and your staff have gone out of your way to make us feel welcome and to make this event a success, and also to help our staff from Topeka to work on it. We appreciate your hard work and enthusiasm. We extend a warm welcome to Superintendent Bren, Principal McNamara, and all the educators, staff, and students who are in attendance this evening. The session is being video streamed. We appreciate the expertise of the high school staff who are making that possible. I also want to thank all the law enforcement and security personnel who have assisted in planning and providing security for us on our trip to Colby. A special thank you to the Thomas County Sheriff's Department, Kansas Highway Patrol, and the Colby Police Department. Also a welcome to Chief Judge Kevin Behrens and the other judges and court staff of the 15th Judicial District who are in attendance. Thank you for your assistance in planning this. We are pleased to be holding our 15th travel docket in the 15th Judicial District of Kansas. Also, a special thank you to our honorary bailiff, Judge Jack Burr, a senior judge from Goodland. He's the one who asked you to rise as we came in. He has devoted 40 years to the judicial branch as a district judge and as a senior district judge. He was appointed a district judge in 1978, and after serving 30 years as a district judge, he achieved senior judge status, which made him available to serve on an as-needed basis in courts across the state. He has served on Court of Appeals panels, and he has sat with the Kansas Supreme Court. Judge Burr, we commend you on your many years of public service, and we thank you for opening session this evening. Not a well-kept secret, but Judge Burr likes to collect antique saddles and spurs. So you might want to check him tonight to see if he's wearing any spurs. And I believe if he is, that would be a first for a Kansas Supreme Court bailiff. We welcome the Thomas County Bar Association members who are in attendance. We enjoyed our luncheon with you today. And I also want to indicate the school visits that my colleagues and local judges participated in this afternoon. First, Colby High School was Justice Beyer and Chief Judge Karen Behrens. Colby Community College, Justice Rosen and retired Chief Judge Glenn Schiffner. Oakley High School, Justice Stiegel and District Magistrate Judge Mark Tamont. Northwest Kansas Technical College, Justice Biles and District Judge Scott Showalter. Goodland High School, Justice Lukert and District Magistrate Judge Paula Keller. Rollins County High School, Justice Johnson and District Magistrate Judge James Schroeder. Brewster High School, Justice Lukert again, and District Magistrate Judge John Chahoy. Students from Quinter High School joined the students at Oakley High School, and students from Wallace County High School joined the students at Northwest Kansas Technical College. In total, it's estimated that 1,000 students attended these sessions this afternoon. We want to thank all of you for coming this evening and for making history with us here tonight. With your help, this should be a great session. And we invite you to a reception in the Commons area at the conclusion of the hearings. We greatly welcome the opportunity to shake everyone's hand and to visit with you there. I'm now going to ask Mr. Doug Shima, the clerk of the Supreme Court of Kansas, to do the honor of calling this evening's docket. Mr. Shima.
If the attorneys could come up, please. Thank you, Your Honor. May it please the court. The docket for Monday, April 9th, 2018 consists of two cases. First case, appeal number 112573, State of Kansas versus Daniel Bartlett, Wyandotte County. Briefs both sides.
May it please the court, Sam Shire of the Kansas Appellate Defender Office appearing on behalf of the defendant appellant, Mr. Daniel Bartlett, present and ready for argument.
May it please the court, Assistant District Attorney Daniel Obermeyer here for appellee, present and ready for argument.
Second case, appeal number 115434, LCL LLC versus James Phelan and Rice County Abstract and Title Company Incorporated, Rice County. Briefs both sides.
William Denning and Caitlin Marsh Blake on behalf of the appellant, Rice County Abstract and Title, here ready for argument, Your Honor.
Gordon Stull with Stull, Beverlin, Nicolay, and Haas in Pratt, Kansas, appearing for the appellee, the Phelans.
Your Honor, that concludes the docket for April 9th, 2018.
Thank you, Mr. Shima. I wanted to announce, you've heard that we have two cases on the docket. I will call the first one at this time. That is case number 112573, State of Kansas v. Daniel Bartlett. And we will not take a break in between the two cases. So if anybody in the audience feels a need to leave, please exit quietly. And we hope you do come back.
May it please the court. Sam Shire of the Kansas Appellate Defender Office appearing on behalf of the defendant appellant, Mr. Daniel Barlett. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is granted.
Thank you, Your Honor. I'll start with the first issue raised in Mr. Barlett's petition for review, whether the district court erred by refusing to instruct the jury on a requested self-defense instruction. The Court of Appeals affirmed the district court, holding that it would have been legally inappropriate to instruct on self-defense because Mr. Barlett was charged with felony murder. That holding of the Court of Appeals was based upon a holding of this court in State versus Bell. In Bell, this court held that a statute, which is now cited as KSA 215226, does preclude instruction on self-defense when a defendant is charged with felony murder. So that statute, KSA 215226, says the justification described in Kansas's self-defense statutes is not available to a person who is attempting to commit, committing, or escaping from the commission of a forcible felony. I'd like to start our argument by setting forth what I believe the legislature had in mind when they enacted this statutory provision. I believe that the basic situation would be that if somebody, for example, were to commit a burglary, and in the course of a burglary, the homeowner became notified of the burglar's presence and persuaded them to leave his or her house by means of force. Usually, in a situation like that, if somebody is threatening you and using force against you, you have the right to self-defense. That's a statutory right in Kansas. But what KSA 215226 says is that because you are in the middle of committing a felony, you don't have that right. So if you try to use violence or force on the homeowner to defend yourself, that you will be held criminally responsible for doing that. So that basic principle that you do not have the right to self-defense while committing a felony, I do not believe supports the holding in Bell that it is always inappropriate to instruct on self-defense in a felony murder case.
If Bell was incorrect in determining what the legislative intent was, the legislatures had 15 years to correct that, and they have not done so. What do we make of that?
From that inaction, I don't think that there's much to be drawn, Your Honor. There was a Kirkpatrick case that dealt with this same issue. I'm not sure that this has been an issue that has been recurring over and over again in the Kansas Supreme Court, although it is an important issue. And I believe that at a certain point, this court has to be driven by more basic rules of statutory construction, plain language interpretation of statute, and avoiding an absurd result. And I think if you look at a plain language interpretation of statute, what KSA 215214 says is it's not available to someone who is committing a felony or escaping from a felony or attempting a felony. The problem with Bell is it doesn't contemplate that sometimes people are going to want to argue, criminal defendants are going to want to argue that I did not commit a felony because I was acting in self-defense. And if somebody did not commit a felony because they were acting in self-defense, there is no felony to support a felony murder conviction. So I don't think the plain language of KSA 215226 supports the holding in Bell. I also believe that it would lead to absurd results. And those absurd results were detailed in a dissenting opinion in State versus Kirkpatrick. But basically, the absurd result is that the states, based solely on the way they choose to charge a case, can take away somebody's right to self-defense.
How does self-defense work in a case like this on an aiding and abetting theory? Are you arguing that that your client, Mr. Barlett, has the same intent as the shooter here, or can he have a different motivation for self-defense?
Well, it's possible. The answer is possibly both, Your Honor, but our argument would be focused primarily on Mr. McKeon's actions, whether Mr. McKeon was acting in self-defense. Because if Mr. McKeon is acting in self-defense, he's not guilty of a crime. And without a guilty principal, you can't be guilty as an accomplice.
And then that gets complicated on remand because Mr. McKeon has now pled to second-degree murder, correct?
That's correct.
So how do you argue that he was, as an aider and abettor, is acting in self-defense when he's pled to an intentional homicide?
Right. Your Honor, I think the answer to that is that Mr. McKeon has waived his right to a jury trial on the state's charges. So there was a time when he would have had the right to a jury to decide whether he was acting in self-defense. He decided it was in his best interest to cut his losses and plead guilty to a lesser charge. And that's the way the criminal justice system works. Obviously, that's what happened in this case.
But it's to a lesser charge in which he acknowledges he wasn't acting in self-defense.
Well, that wasn't his trial testimony. His trial testimony was that he believed himself to be acting in self-defense. But I don't think every case has to be tried on a case-by-case basis. If Mr. McKeon had been acquitted of felony murder and criminal discharge, Mr. Bartlett couldn't come into his trial and say, this is a decided matter. My co-defendant was acquitted of these charges, so I'm obviously innocent too. That's just not the way it works. So that would be my answer, Your Honor.
If we were to agree with you that the Court of Appeals was incorrect in finding that the instruction was legally inappropriate, why wouldn't we find that it was nevertheless correct for the wrong reason because it was factually inappropriate? You have to pass muster on both counts, right?
That's correct, Your Honor. And the district court, unlike the Court of Appeals, ruled on both the legally appropriate and factually appropriate aspect of the instruction. I believe the district court was wrong in holding that it was factually inappropriate because if you look at trial evidence in the light most favorable to Mr. Bartlett.
And the light most favorable is that Mr. Bartlett was driving a vehicle that was in pursuit of the vehicle that contained the decedent.
I don't agree with the in pursuit in the light most favorable to Mr. Bartlett. If you look at the interrogation statements made by Mr. Bartlett, which were admitted into evidence, he says that he saw his friends drive by, he pulled a U-turn to get behind his friends, and that he ended up behind the car in which Mr. Ford was riding as a passenger by happenstance. So that's evidence in the light most favorable to the defense that there was no dispute. Now that is not what the testimony of Mr. McKeon was, but again, in ruling on the factual appropriateness of a self-defense instruction, the district court was required to look at trial evidence in the light most favorable to the defense.
To your client. Does the record tell us how far they traveled once they turned around?
It would have been a relatively short distance. I know a map was admitted as evidence.
Is that in the record on appeal?
I don't recall at this time.
Okay.
What do we make of the fact that the friends went one direction, but your client pursued the car of the victim and went at the other direction when there was a fork in the road?
Two answers, Your Honor. First, according to Mr. Bartlett's interrogation statement, he was not intentionally following after Mr. Ford when he took that fork in the road. So that's the first answer. The second answer is that I think a jury would not be compelled to find that Mr. Bartlett was an initial aggressor or engaged in mutual conduct just because he's following a vehicle that he believes is chasing his friends. That's a lot different, in my opinion, than engaging in conduct that's egging somebody on to engage in a gunfight, basically. And again, if you look at trial evidence in the light most favorable to the defense, and there was absolutely conflicting evidence at trial, I think it's apparent even from a cold record that all of the witnesses were bringing bias into their accounting of their events. What the jury made of that, only they know. But if you look at evidence in the light most favorable to Mr. Bartlett, Mr. McKeon was returning fire on Mr. Ford after Mr. Ford began shooting him. And he testified that he did that because felt that he was in imminent danger of death or great bodily harm. So I think that establishes evidence that would support a self-defense instruction. So what should have happened in this case is that the district court should have instructed on self-defense, should have given an initial aggressor instruction, should have given a mutual combat instruction, should have given a no duty to retreat instruction, basically instructed on the full state of the law of self-defense in Kansas, and then let the jury decide what they wanted to do. In Kansas, there is no right that is more fundamental than the right to a jury trial, and I don't believe that Mr. Bartlett was fully afforded that right in this case.
Can you explain to me how, again, on a theoretical basis, now jumping ahead to your client, he has subsequently pled to voluntary manslaughter. So now how does it work when the act that gives rise to the manslaughter is done in self-defense, but you've taken responsibility for the killing? Doesn't they taking a contradictory stand to what the reality is? He stands guilty of that crime, has been sentenced for that crime, and in fact has been given credit for taking responsibility in a reduced sentence for that crime. How do we factor in that?
Well, I don't think it really factors in at all in this court's analysis. And my reason for that is basically a guilty plea is a contractual agreement between a criminal defendant and the state. And Mr. Bartlett made his own decision that it was in his best interest to plead to this lesser crime to avoid the possibility of getting a life sentence.
Any case law to support that? Because that a guilty plea is a contract. I recall the case law says a guilty plea is an admission of all the elements.
Well, I suppose I should say plea agreement.
Okay.
Pursuant to a plea agreement, he pled guilty, would be the more accurate way to state that. But the basic premise remains. And I would say that he has not waived his right to a jury trial with respect to the criminal discharge. And the Court of Appeals found that to be the case. The state elected not to petition from that ruling. So I don't believe that that is an issue.
He's not waived his right, but what happens on remand if he's given a trial on that and there's evidence that he's pled to the crime, really the lead charge of the crime, and the underlying count of discharge of a weapon at an occupied vehicle is what gives rise to the homicide.
I guess the short answer...
How do you do that in self-defense but then admit that you did it in a heat of passion?
Well, and Your Honor, I don't think there's any way to view this as a voluntary manslaughter offense, to be quite candid. This court is...
Well,
but at any rate...
That's what he pled to.
That's what he pled to. The short answer is, when this case is remanded, the attorney for the state, if he wishes to try and get that into evidence, if he or she wishes to try and get that into evidence at a subsequent trial, assuming that a subsequent trial is to occur, the attorneys could dispute and argue about whether it was admissible evidence at that point in time. That would be my answer, Your Honor. And I am not going to say that I know at this time how a court would necessarily rule on that.
We have any further questions? Thank you, counsel.
Mr. Chief Justice, Associate Justices, Counsel, and may it please the court. Again, my name is Daniel Obermeyer. I'm Assistant District Attorney, Wyandotte County for the state of Kansas. Your Honor, since the majority of, well, basically all of Mr. Bartlett's argument revolves around the self-defense instruction, that is also what I will address. First, I think that this court needs to look at the record very strongly in this case, and I would cite volume 11, pages 1486 through 1489 specifically. Before that time, that is where Judge Russell is giving the legal basis he's making for his decision. And in this part of the record, he is addressing the factual basis. Why, factually speaking, it is not appropriate to give a self-defense instruction in this case. And quite frankly, this is what was done in State v. Bell. And in all the other cases that I believe I can find, where a forcible felony is being committed and where the defendant wants to argue self-defense. It doesn't appear to be an absolute bar, the statute 215226. So in terms of that being an absolute bar to a defendant claiming self-defense, I don't think that's the case.
It's not absolute, but doesn't it leave all the power in the prosecutor?
No, it does not, Your Honor.
How not?
Because the statute does not say if a defendant is charged with a forcible felony. The language of the statute, if I may be precise here, is if a person is attempting to committing or escaping from the commission of a forcible felony.
How do you know whether that is true or not?
Well,
If you don't rely on the charge.
Well, there has to be evidence to support that claim, is what I would argue, and that's why jury instructions are always fact intensive, and that's what the court.
What's the evidentiary, or what's the standard of proof? I mean, is it just like preliminary hearing? If you get past the preliminary hearing, then there's evidence. Is that enough?
In terms of whether the state has made a prima facie case that they're committing or
correct.
Okay. I would say that when we're looking at it in the trial setting, the state's put on evidence that the defendant has committed this crime. That's enough from that point of view to show that they are in the commission of
And
crime.
isn't homicide itself a forcible felony?
Yes, it is, Your Honor.
So how does a defendant ever get self-defense once at trial? Once the state's proved up its case enough to get to a jury?
Well, what this court has considered, and I note that Bell also considered this, and the trial court, Judge Russell, also cited State v. Gonzalez in his decision when he was analyzing the factual appropriateness. The relevant evidence must establish that the defendant honestly and sincerely believed that it was necessary to kill in self-defense, and a reasonable person would have perceived that necessity. So that's the defense burden, if you will.
That's on the facts, though, right? Are you conceding that the instruction was legally appropriate here?
I don't know if I'm conceding it's legally appropriate, Your Honor. I'm just saying I don't think that that is really before the court, since the majority, I would submit the majority of Judge Russell's decision was based on the factual.
Doesn't our sort of analytical path we take on these, doesn't it start with legal appropriateness and only get to factual appropriateness second?
Well, yes, Your Honor, that's true.
I understand you're resting, at least in part in this case, on your argument that it's not factually appropriate. I would like to know where the state stands with regard to legal appropriateness.
Well, the statute, I just have to say that the plain language of the statute, I mean, the way that the courts have applied it, it seems to be that we take this factual.
Were we wrong in Bell and Kirkpatrick then, when we said that it was if you're charged with a forcible felony precludes getting a self-defense instruction? Pretty much said that.
I wouldn't say that you are wrong in that, Your Honor.
So he's charged with a forcible felony.
Correct.
Would bar him from legally anyway from getting the instruction. You don't even need to get to the factual analysis.
Well, in Bell, and I believe in Kirkpatrick as well, this court addressed the factual underpinnings as well. So just from my point of view, it's hard for me to distinguish that in this analysis.
In Kirkpatrick, it was pretty cryptic, wasn't it? Just, we're going to limit this case to its facts with no explanation.
Those I have no comment on that, Your Honor.
Okay.
But I think that if we look at these cases and decide them according to the facts that they're presented, that Judge Russell ultimately made the right call in saying that because of these facts, that Mr. Bartlett was not entitled to self-defense because Mr. McKeon was not entitled to self-defense. Mr. McKeon first didn't testify, and his statement to police, he didn't testify it was necessary to kill, to use deadly force. He said self-defense repeatedly, but he did not use the words to kill. And second, a reasonable person, the second prong that the court used, a reasonable person would have perceived the necessity of self-defense. A reasonable person wouldn't have done that. A reasonable person would not be the aggressor in this situation, sort of provoking.
Well, wasn't there a very serious fact question here? McKeon testified that he and Bartlett were shot at twice before any firing was done by them.
Correct.
So why isn't that just a disagreement on the facts at the best, but in the light most favorable to Mr. Bartlett, why isn't that sufficient?
Because there has to be some corroborating evidence to support that statement, Your Honor. In, for example, State v. Mathis, considering that counsel cites in his brief, the appropriateness of a self-defense instruction in that the defendant claimed that the victim was wearing a bulletproof vest, that he was armed, and that he was unstable, essentially. And there was nothing other than the defendant's testimony to corroborate that. So, yes, you'd look at the evidence in the light most favorable to it, but by the same token, if there's nothing else, then it's not really appropriate to give that instruction.
Explain that to me. We look at the evidence in the light most favorable to the defendant, but the defendant has to show corroborating evidence.
Yes, there has to be. That was the one of the points in Mathis, Your Honor, that there was nothing really to corroborate the defendant's version of events, if you will. So the district court did not.
Well, if you're weighing credibility of the defendant's statement, how is that looking at the evidence in the light most favorable to the defendant? That's a weighing of the evidence, or is assessing credibility, which is completely different than taking the evidence in the light most favorable to one side or the other.
I guess I would distinguish that. I would distinguish that, Your Honor, by saying that, you know, the light most favorable to the defendant, it can't just be their own testimony. There has to be something independent of that to corroborate that. And if that's lacking, then even the defendant's, if there's nothing to support the defendant's story, then it's hard for the court, in exercising its gatekeeping function, to give on what instructions to give. Should take that into account.
So if a case is just a pure credibility determination, the defendant never gets a self-defense instruction. If it's just he said, or he said, she said.
Well, not hypothetical, Your Honor, I would say that if it's just testimony on both sides, then the defendant would probably be entitled to a self-defense instruction. If there's nothing to corroborate state's witnesses, nothing to corroborate the defense side.
Well, was there any evidence put on by the state here that would have tended to disprove the testimony of the firing, the shots being fired?
The testimony, I'm trying to remember if it was the statement or the testimony of Mr. McKeon, that they recovered the revolver that was held by Chad Ford, and they disposed of the bullets. It's not known where they were disposed. They didn't tell police where, so those were not recovered. So allegedly, those the two fired shell casings that would have corroborated their story were not present for the jury or the court to consider. So in that circumstance, no, there was nothing really to corroborate their story. And the undisputed evidence was that Mr. Bartlett made a U-turn, came back around, sped up, kept track with the blazer containing the victim, and then through his assistance, Mr. McKeon was able to get shots off, one of which hit and killed Mr. Chad Ford.
Even if you can't corroborate the firing of the shots by the victim, it does seem that there is evidence corroborating that he had a gun held outside the car. There's DNA on the gun, and the gun drops to the pavement, and the victim falls back into the car. So it seems like at a minimum, at light most favorable to the defendant, there was a gun pointed at them, which could have Why wasn't that enough for self-defense instruction?
Because of the circumstance leading up to that. The defendant is driving towards them, putting themselves in this dangerous situation. The testimony, there was testimony that the defendant knew that these people were armed. So he's putting himself in this dangerous position. And I would note that under 215226B, basically you can't provoke someone into doing violence on you so that you in turn can kill them.
Right. Provocation and failure to avoid are two different things, of course. Why isn't this just a jury question? I mean, what would be so wrong if we flipped Kirkpatrick and Bell and said, this is a jury question?
Well, first, I think that it would run contrary to the intent of the legislature, which wants some safeguard on defendants who commit forcible felonies not being able to claim self-defense under appropriate circumstances. So I think that for that reason, it would be appropriate not to overturn Bell and Kirkpatrick. And second, I think that the analysis we currently have, which is mainly looking at the facts surrounding a case and then determining from that whether or not it's appropriate, and of course doing as the court did in this case, construing them in the light most favorable to the defendant, whether or not it's appropriate to give an instruction. I think that those are fairly good safeguards already.
Do we have pieces that don't fit here because Bell and Kirkpatrick were decided before the framework that we're now talking about of moving from legal appropriateness to factual appropriateness? At that point, that stair step was not clearly delineated in the case law. Do you think that's the problem we're having?
Potentially it could be, Your Honor, because if you look back, if you just reread the Bell case, it certainly does address the facts surrounding whether or not it's appropriate. And I think that, you know, that has evolved over time to what we have, the status quo we have right now, where the court knew its duty. It was to consider whether or not it was factually appropriate, and it did that.
Counsel, help me, excuse me, walk through this very simply.
Mm-hmm.
Under 215226, what forcible felony are we talking about in this case?
It would be criminal discharge of a firearm.
And can that charge peacefully coexist with a claim of self-defense?
I'm sorry, Your Honor, I'm not quite sure I understand that.
Well, if you have a situation where two people are shooting at each other, it sounds to me like the state can charge one of them with a forcible felony. And when that defendant says, but I was defending myself, the state points to the statute and says, you can't do that when it's a forcible felony and you're shooting at this other individual. So why have the defense of self-defense in a case involving a forcible felony? If you could explain that.
Well, I think that in a case where the defendant is charged with criminal discharge, and you have this scenario, then the court has to look at the facts and determine whether or not it's appropriate to give a self-defense instruction. That would, and as far as the legislature is concerned, I can't really say I have a good answer for that, except to say that the language of the statute doesn't preclude someone from asserting self-defense because
why not? Why wouldn't it? If you're saying that the act of defending yourself in a deadly force scenario would always be a forcible felony, potentially, if self-defense wasn't justified, right?
Yes.
So anytime you have a claim of self-defense, you also have a forcible felony. And if you're going to interpret 5226 C1 or C, or A, I mean, is attempting to commit, committing, or escaping from, as meaning the act of self-defense itself is potentially a forcible felony, then self-defense doesn't exist in the deadly force scenario. Is what I understand the chief is asking.
In that hypothetical, I can see that as being possible, yes. However, I think.
Well, no, really, if you interpret subsection A is attempting to committing or escaping from the commission of a forcible felony, being discharging the weapon at the occupied car, that was the claimed act of self-defense, then bright line rule, there is no self-defense. And I'm asking, how can there ever be self-defense in a deadly force case when the response is always going to be a forcible felony if it's not self-defense? You understand what I'm asking you?
I do.
The bright line rule is self-defense doesn't exist in the deadly force, if we interpret it the way you're asking us to.
Well, Justice Johnson, with all due respect, I don't think I'm interpreting you to interpret 2150-26A as being, if someone is charged with a forcible felony, that means self-defense is precluded them. I'm sorry, I thought I don't want to, I don't think that that's provided for.
You don't think Bell and Kirkpatrick said that?
Well, they said it only in the most literal sense of it. The actual analysis of Bell, for sure,
They said it, but they really didn't mean it.
It looked at. I
understand. I'm not going to hold you to the language of those, but you understand what our dilemma is here.
I understand, Your Honor, but I just want to assert that what I think is being done in precedent, and what I think was done here, is a thorough factual analysis to determine appropriateness. I see that I am out of time. Unless there are any more questions, I would ask to briefly sum up.
Do we have any more questions of counsel? Since we've taken a lot of your time with our questions, we'll give you 60 seconds to sum up.
Thank you, Your Honor. Much appreciated. Essentially, we're asking the court to affirm the Court of Appeals on all of the issues that are now before the court. Simply put, with the jury instructions, the district court followed the law to the letter in each of the jury instructions. For self-defense, following the case law there, and giving a factual analysis to support that. For the mere association instruction, also following the case law and the literal words of the PIC. I would note there that the main defense in Bartlett's closing was self-defense, with mere association sort of being tangentially woven into there. So not only was he not precluded from, making a self-defense defense, but also a mere association defense. On the whether or not intentionally must be instructed for the aiding and abetting, I would refer this court to the Court of Appeals again, State v. Betancourt, saying that it's a principle of criminal liability. It is not itself an element requiring instruction. And finally, the court did not abuse its discretion when the state faced technological issues in playing State's Exhibit 2, Mr. Bartlett's confession. We'd ask you to affirm the district court and the Court of Appeals. Thank you, Your Honors.
Thank you, counsel. You're reserved 3 minutes for rebuttal.
With rebuttal, I guess I'd just like to comment on how I read Bell and Kirkpatrick. As I interpret Bell, what it literally says is that if you are charged with a forcible felony, you are not entitled to a self-defense instruction. I don't think that literal holding has ever been followed by Kansas appellate courts, because if it were, you would never instruct on self-defense ever. Basically, every act of self-defense in a felony case could be described as a forcible felony if self-defense were not invoked. So what I think Bell was holding, which I also believe is wrong, is that it is never appropriate to instruct on self-defense in a felony murder case. And I think the error of the Bell court was basically that its reasoning was circular. It was saying that because there is a felony inherent in a felony murder charge, that self-defense cannot be a defense to felony murder. I think that's what the Bell court was trying to get at. And I think the problem with that legal analysis is that a self-defense claim to the underlying felony would take away the commission of a felony, the element, an element of felony murder. And I know that that is very convoluted to explain, which is probably.
But what you're saying is that you can have, because felony murder is defined as during the commission or before, during, or after the commission of a felony. And if you're doing that, then you fit right into the language of the statute. But what you're saying is you can still impose or ask for self-defense for the underlying felony, not for the death. Is that what you're saying?
That's exactly what I'm saying, Your Honor. And to be clear, when you give a self-defense instruction on a felony murder case, it should cut only to the felony element of the felony murder charge. You're saying, because I acted in self-defense, I did not commit a felony. And
That
because
would
I did
only-
not commit a felony, I'm not guilty of felony murder.
And that would be applicable only when the underlying felony is the kind of felony that is subject to a self-defense defense. I mean, you can't plead self-defense to a burglary charge.
Exactly,
Right.
Your Honor.
And that would potentially at least resolve both the statutory language and the spirit, if you will, of Bell. Is that what I'm hearing you say?
That's exactly right, Your Honor. This type of issue would not come up typically in a burglary felony murder case or a drug transaction felony murder case. Unless this court has any further questions, I am prepared to conclude my argument at this time.
Any more questions? Thank you, counsel. We thank both of you for your arguments this evening. Court will take this matter under advisement. Now turn to the second case in this evening's docket. That is case number 115434 LCL LLC v. James W. Phelan et al. Appellants v. Rice County Abstract and Title Company Appellees.
May it please the court. William Denning on behalf of Rice County Abstract and Title. Mr. Chief Justice, I would like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Mr. Chief Justice and Associate Justices, we are here tonight because the Court of Appeals ignored and misapplied well-settled Kansas law in holding that the 2-year statute of limitation did not bar the Phelan's claims for negligence and breach of fiduciary duty against my client, Rice County Abstract and Title. In a well-reasoned and thoughtful opinion, the trial court originally granted summary judgment in favor of my client, holding that the 2-year statute of limitations barred their claims. The Court of Appeals reversed that decision. And in doing so, they ignored this court's precedents and well-settled Kansas law about when the statute of limitations begins to run.
Counsel,
Yes.
can we just go back to the beginning a little bit on this? And I'm specifically interested in the way that you moved for summary judgment originally. Did that motion include facts about not only when the deed was filed, the 2008 deed was filed, so when the negligent act supposedly occurred, but when the injury occurred? Not just the negligent act, but the injury, because they're distinct, aren't they? At least theoretically distinct.
I think they're theoretically distinct, Your Honor, but I think they're one and the same. The date the deed was filed, our argument at the Court of Appeals.
That's your legal position. That's your legal position, right? I believe as the summary judgment pleadings went back and forth, one of your responses to your esteemed opposing counsel was that when he said we never lost possession of our mineral interest, you said that's a legal conclusion. So I think that what's good for the goose is also good for the gander.
Well,
And
and I think there's a difference between possession and ownership, Your Honor. And
Right.
that's the distinction that we drew at the trial court level, is that when the deed was filed on January 18th, 2008, as a matter of law, the Phalens lost ownership of that property.
Let's explore that for a moment, the as a matter of law part. There's no dispute here among the parties that there was a mutual mistake.
There's
right?
not, Your Honor.
There's no dispute. And if in fact there was a mutual mistake in the conveyance, then that deed was subject to equitable reformation, wasn't it?
It could have been, Your Honor. If it would have been timely brought, yes, it could have been.
Okay. And one of the things that as a matter of law can cut off that reformation is a bona fide purchaser. But again, there's no dispute here that the second purchaser in 2014 was aware that there had been no intention between the parties in 2008 to transfer that mineral interest, right?
There's an email or a statement in terms of the correspondence that he does represent that he understands that the mineral rights are not being transferred with the property. That's correct, Your Honor.
Okay. Well, given that we have this property law, basic property law, about the ability to reform a deed that's filed and contains a mutual mistake or records a mutual mistake in a real estate transaction, how can we say, as a matter of law, that the injury, be it substantial or actionable, whichever term you want to apply to it, occurred at the same time that deed was filed, as opposed to sometime later when the opportunity to reform was no longer available?
And because I think, Your Honor, the reason you can say that that injury occurred on the date the deed was filed is because of this court's jurisprudence. The case law in this court is that when a deed is filed and it doesn't include information reserving an interest, such as a mineral interest, that mineral interest then transfers to the subsequent purchaser. So in this case, it transferred from the Phalens to Mr. Dean upon filing of that deed. You can also look at Kansas statutory law, which says, and I believe it's KSA 58-2202, that if a deed does not contain a reservation, it passes full title to that property. And that's why the fact of injury would have occurred when that deed was filed versus some time later on, because regardless of whether there was a mutual mistake, ownership of those mineral rights were transferred to Mr. Dean upon the filing of that deed. The Phalens could have walked down to the courthouse the very next day and filed a claim against Rice County saying, we lost the ownership of those mineral rights.
Let me ask it a different way. In 2014, when the deed was made to your client, or to LCL, if your client had checked the record correctly and discovered the true ownership, discovered the reservation, included that in the deed from Dean to LCL, would we be here today? LCL would not have had a claim to those minerals, would it?
Correct, Your Honor, but I don't think my client could have unilaterally altered the deed once that property had already been transferred to Mr. Dean. I don't think my client, Rice County, has the ability to say, we found this mistake.
Well, they tried to correct it. They tried to get a correcting deed.
They
but
did.
What I'm saying is that Mr. Dean wasn't asserting ownership. Mr. Dean knew that the intent of those two parties to that contract was that he didn't get the minerals. He didn't assert the right. He would have lost in a reformation case because he would have had to say, hey, I know I didn't buy it. I didn't buy it. And so the Phalens didn't lose ownership vis-a-vis Dean, because between Phalens and Dean, they knew what their agreement was and they were all on the same page. Where the problem arose is when you brought a third party in with the incorrect or failure to discover the mistake in 2014. So why isn't that when the injury occurred?
Because they lost the ownership right as a matter of law by this law.
If you could file a reformation action and retain your ownership, how did you lose it as a matter of law?
And Your Honor, I don't know what would have happened if they would have filed a reformation. There was actually a quiet title action between LCL and the Phalens, and the Phalens chose to settle that action.
You're missing my point there. That's bringing the third party into here.
Right.
I'm saying that when the third party was brought into this is when the trouble arose for the Phalens. As long as it was Dean and the Phalens that made the agreement and made the sale there, everything was all okay. It was when Dean brought a third party in. And so I'm still not understanding why that isn't the point where it changed everything.
And I would disagree with Your Honor that the point that became an issue for the Phalens was when you brought the third party in. The issue for the Phalens was once that deed was filed on January 18th. That's when they lost ownership. The Court of Appeals went through a history about transfers that the Phalens attempted to make with this half mineral interest ownership. All of those transfers are void at that time because they didn't have ownership of the property. So they were attempting to exercise dominion, they were attempting to transfer the property, and they couldn't do it. So it's not that their injury occurred when LCL refused to transfer the property back to them. Their injury occurred when they lost ownership of the property, and that was January 18th.
They didn't lose the entire ownership of the property because, as we learned in property class, there's the bundle of sticks.
Correct,
They
Your Honor.
retained part of that bundle
They
in the
did.
form of royalty checks every month or whatever they were paid. So they still retained part of the bundle of the ownership, didn't they?
They did, Your
Yeah.
Honor. And Your Honor, I would
Even if
point
we-
the court to Sutton versus Sutton, which is a Kansas Court of Appeals opinion, where there was a divorce action and the wife thought that she was going to be deeded the property, and she remained on the property when it was transferred back to her mother-in-law. She remained on the property for a period of time. So she had the use and enjoyment of the property. When the mother-in-law died, she found out that the property was not going to be transferred back to her. So she filed a cause of action against her husband, trying to bring the property into the marital estate. And the Court of Appeals held that the date she lost the property, the date she lost ownership, was when that property was transferred to her husband and she wasn't included on the deed. And that her cause of action accrued at that time, even though she continued to live on the property, enjoy the land, and profit from the land. The fact of the matter is the Phalens did in fact lose, when we talk about the bundle of sticks, the key bundle, the key stick, which is ownership of that property. At that point, they no longer had the right to transfer the property. In fact, they no longer had the right to receive those royalties. Had Mr. Dean chosen to do so, he could have asserted a right to those mineral interests and to those royalties had he chosen to do so, because the right to the royalty arises out of the ownership of the mineral interest, because we have two distinct property interests there, a real property interest and a personal property interest. And that was part of the error that the Court of Appeals had, is they focused solely on the royalties.
Am I
You're saying
looking
the
at
royalties are personal property, but we're really talking about the minerals interest.
We are, Your Honor.
One half undivided interest in the minerals, and that's corporeal property, real property.
And we are, Your Honor, and that was
Yeah.
the problem with what the Court of Appeals' analysis was, is the Court of Appeals focused solely on the loss of the royalties when they determined that the statute of limitations began to run in August of 2014. And they tied that directly to the loss of those royalty payments.
Why, even if we accept all of that, why isn't there a new act, a new injury in 2014 when the transfer to a third party is made and the right to reformation ends? That's a new act, a new injury. And you may have other legal defenses besides statute of limitations to all of that, but based upon the allegation that your client should have notified the Phalens of their mistake earlier before that third party transfer occurred.
Because, Your Honor, I don't think the act which gives rise to the injury occurred in 2014. The act that gave rise to the injury was the filing of that deed on January 18th. Without that initial act, the purchase in 2014 by LCL is irrelevant. There's no injury during that but for what happened in 2008 with the incorrect deed.
I understand there's a thread there, but isn't there a new injury in 2014?
Your Honor, I would disagree.
act?
Your Honor, I would disagree that it's a thread. I think it's a rope. You don't get to 2014 absent the injury in 2008. If the deed is properly prepared in 2008, when Mr. Dean transfers the property to LCL in 2014, there is no injury. So the act giving rise to the conduct, which is what KSA 60-513 tells us to look at, is the act giving rise to the injury occurred in January of 2008. The injury was the loss of ownership. And that's why it all goes back to January 18th, 2008, when that deed was filed.
What damages occurred as a result of the loss of ownership under your theory during the statute of limitations period? They were receiving the royalties. They had to pay. So what cause of action existed at that time?
Well, Your Honor, I think in the record, it shows what they sold the property to Sammy Dean for, which was $203,000, I think. Obviously, that $203,000 did not include the value of those minerals. Separate and apart from the royalty payments. Had they been selling the minerals too, presumably they would have asked for more than $203,000. In fact, that's exactly what the Phalens asked for in the petition that they filed against RCAT, Rice County Abstract and Title, was the value of those mineral interests. They could have walked down to the courthouse the day after that deed was filed and filed suit against RCAT for the loss of the value of those mineral interests because they no longer owned them. And that was one of the injuries that they suffered. The other injury that they suffered, Your Honor, was the fact that they no longer had control. One of the bundles of sticks that we talk about in property is the fact that you can dispose of the property. As I said, they attempted to transfer the property a number of times. Those transfers are void because they didn't own the property at the time they were trying to transfer those mineral interests. So they also lost.
They were effective at the time. You say they were void, but they were effective at the time, and they effectively transferred the minerals interest. Did they not?
I would disagree.
Didn't the grantees under those conveyances then come into proportionate share of the income off the land?
And Your Honor, the record doesn't reflect that at the Court of Appeals. My argument would be is that they weren't effective because you can't transfer title to property which you don't own.
But everybody behaved as though they were. Everybody behaved as though it had been done properly until 2014, which is what brings you to Justice Lukert's question. Wasn't 2014 a new ball game once they introduced a new player?
And Your Honor, I think that the context of the case changes when you add a new player, but I don't think that changes the analysis as to when the injury occurred. The fact that LCL asserts a claim in 2014 is not a separate and distinct injury from what happened in 2008.
Why can't a negligent act produce multiple injuries that don't occur simultaneously? And isn't that what foreseeability is all about? That you can commit a negligent act that doesn't manifest itself in an injury until sometime in the future, perhaps far into the future. And you will be liable for that only if that injury is foreseeable.
And Your Honor, I think in this case, the fact that they lost ownership in 2008 makes it reasonably foreseeable that somebody in the future could assert an interest to those royalty payments. So I think that was a foreseeable injury that occurred when the deed was filed. Secondly, my response to that would be, Your Honor, is it's the fact of injury, not the extent of injury, that starts the statute of limitations running in this case. And that's this court's jurisprudence. That's well-settled Kansas law. And the fact of injury was the loss of ownership in 2008.
Do you deny that in 2014, when your client was handling the LCL sale or purchase, that your client committed professional negligence by failing to discover that there was a problem with one half of the minerals on this property?
Your Honor, I don't think my client failed to discover that in 2014. I think the record reflects that they did, and they tried to correct that problem with LCL.
So there was negligence that occurred because they issued the deed. They issued the deed before they discovered the problem.
And Your Honor, I don't think that's a separate act of negligence that would apply to the Phalens in this case. And the reason it wouldn't apply to...
Was it negligent? Was it negligent to prepare the LCL title opinion? They issued a title opinion, and if I'm a purchaser of the property and your client gives me a title insurance and says it's whole, and there's a half undivided interest that's floating out there that's subject to litigation, I'm thinking you committed professional negligence. Do you disagree with me?
Your Honor, I would not say that what occurred in 2014 was necessarily professional negligence because the deed that had been filed in 2008 didn't reflect that mineral interest. The way my client discovered it, I think.
But you don't look at deeds. I've done a lot of stand-up title opinions. You look at the property taxes, you look at the appraiser's office, you look at all kinds of other documents in the courthouse besides just the deeds. And there were plenty of indicia that the Phalens were getting paid for these royalties, weren't there?
There were, Your Honor.
And I'm expecting my abstractor to find those. And you're telling me that you don't think that was negligent to fail to see that the Phalens were getting half the royalties?
Well, first, Your Honor, in the 2014 transaction, Rice County Abstract and Title didn't act as an abstractor for the Phalens. It acted as an abstractor for LCL and Mr. Dean. So if there was a negligence there, presuming that there was, that negligence doesn't apply to the Phalens. It would apply to Mr. Dean or to LCL, who were the parties to that transaction, because the Phalens were strangers to that transaction at that time.
But that's a different defense than the statute of limitations. We're just trying to hone in on the statute of limitations tonight for obvious reasons. That's what everybody's been litigating up till now. So you'll have more defenses if you end up back in district court on breach of fiduciary duty in 2014. My colleague's just trying to get you to focus on whether that's an independent act of potential professional negligence that could be actionable. You're saying not by the Phalens, we
Right.
get that, but it's not a statute of limitations problem, is it?
But I think it does, Your Honor, I don't think you can look at that actionable negligence in a vacuum and say it is or it isn't without looking at the statute of limitations as it relates to the Phalens. If it was an independent cause of action in 2014, the Phalens causes of action against my client are still barred because those arose in relation to the 2008 transaction, not the 2014 transaction.
Counsel, would you agree that with the 2008 transaction, that at least one injury that the Phalens suffered was the need to do the equitable reformation? I mean, once that deed got filed, they had a right to go to court and reform that deed. And if they didn't, they were going to lose their mineral rights. I mean, there's a ticking bomb at that point, right?
There is, Your Honor, but I don't know if you would necessarily have to do reformation of the deed. Mr. Dean may have quitclaim deed or issued the deed back.
I understand that, but let's assume that the Phalens had to go ahead and pursue a reformation action. They had a legal right to do that at that time. And if they had to do it, the money they spent to hire a lawyer to fix your client's problem is an injury, right?
Presumably, yes, Your Honor.
We've asked enough questions to keep you from even getting to the question of reasonable ascertainable. And I have a question related to that. Based upon the case law that you have cited even, doesn't the fact that there was at least again, this is an allegation, but an allegation that there was a fiduciary duty, doesn't that change your constructive knowledge argument so that the Phalens had a right to rely on their fiduciary to have done it correctly?
And I don't think that changes the analysis in this case, Your Honor. And the reason I don't think that changes the analysis in this case is because of Kansas statutory law 582202, which provides that if a deed doesn't contain a reservation, then it passes the estate in total. The law in Kansas is that individuals, the citizens of Kansas, are charged with knowledge of the law and the legal effect of their actions. That is a statute in Kansas. I think the Phalens would be charged not only with constructive knowledge of the effect of the deed itself, but with that statute as well, Your Honor. So I don't think the fact that there's a fiduciary relationship changes that analysis.
Do we have any further questions? Counsel, would you like 30 seconds to wrap up, or do you want to wait?
Your Honor,
till
I'll wait till my rebuttal. Thank you.
Very well, thank you.
Mr. Chief Justice and Justices, may it please the court, Gordon Stull, appearing on behalf of the Phalens. I'll just lump them up as the Phalens as we've always called them for the last several years. I would like to first address the issue about basically what the trial court did, and that is the trial court fundamentally relied only on constructive notice to make a determination about the statute of limitations. The trial court relied solely on the fact that a deed had been given and recorded as being the reason for summary judgment to be enforced against our clients. The problem with using that's 582222 as constructive notice as foreclosing my client's rights is twofold. One, in KSA 60-501, it says that that's the statute of limitations section in the civil code. I know you know that, but it says that the terms of the code cannot be varied except by a statute that specifically states it's modifying that code. And in fact, what they want to do here is utilize a recording statute to create constructive notice to modify the 2-year statute of limitations that my client has as a matter of law on negligence and on fiduciary duty. And the fact that should not be allowed to be done.
Isn't your better argument that constructive notice from recording is for the rest of the world? That when you have two people to the contract, the Phalens and the dean, that they should know what their deal is and what was done. And the purpose of recording in the register of deed is to give notice to the rest of the world, not notice to the parties to a contract.
Right, and I agree, Justice. And I was just wanting to point that out. And in fact, it's always boggled our mind in this case that our clients are always have it thrown at them that this constructive notice, they should have known what's going on, because once it was recorded, the whole world knows it. Well, if the whole world knew it, why didn't RCAT knew it? Why didn't they do something about it?
If you're going to mess up, you better rush on down and get that deed file.
Yeah.
That's what it amounts to. What's
Well,
problem number 2? You said there were 2 problems with the 58.
The other problem is in the series of cases that have been developed by the court. I think the last one is the 2013 case of Michaelis versus Farrell, which talks about ascertainable, reasonably ascertainable, and what they found. And this is consistent with what the Court of Appeals did. They relied on these series of cases, which says if you have an issue about that, you don't focus on one single thing, you focus on the whole context of the situation surrounding whether or not the statute of limitations, something happened that would kick it off. And when you do what he did, and that is just rely on constructive notice of one deed, one thing he ignored everything else is for one. And the other is those cases say that the standard is an objective standard. And in other words, what did that person know? What was in their mind? What did they see? What did they hear? What did they know? What did they feel? But the problem with constructive notice, if there was a definition of subjective knowledge, it would be constructive notice. Constructive notice gives you no knowledge. It just pegs you legally with having the legal responsibility about it. So not only do they avoid that, they end up denying the court looking at the objective actions and what my clients knew.
If we're going to talk about the entire circumstance, all of the circumstances, totality, then what do we do with the fact that the deed was in the possession of your clients or their predecessors in interests for 2 days and that they signed it? So, I mean, we're talking a lot about constructive notice at the instigation of your opposing counsel, but what about actual notice and being put on notice they should investigate or ask a question?
Well, they got that deed from people they hired to produce and prepare that deed. They hired RCAT to handle the real estate transaction, to handle the deed preparation, to handle the title examination, and to handle the closing. It was their deed. We did not prepare that deed. RCAT prepared that deed and gave it to us. We had our client had a fiduciary relationship with RCAT, as RCAT being a title insurance or title agent, as in the Ford versus guarantee case. And so we just think that it was not our responsibility. I mean, I guess we could have the responsibility of going hiring another lawyer or hiring another abstract company to make sure our abstract company did it right, but they thought they did it right. The district court made a specific finding that there is nothing in the record to indicate that our clients knew that there was a mistake or that that was wrong.
I can understand an argument that a layperson may not know that a legal description that places the surface someplace on the globe would also carry with it all the minerals underneath. And, you know, that's an argument you could make, but what do we do with the presumed to know the law? If we're going to use an objective standard, wouldn't an objective person be presumed to know the law and know that the surface description carries all the way from the sky to the center?
Well, one, I'm not sure that I would agree that my clients were presumed, or in this situation, my client should be presumed to have known the law. I think in this situation, they had an agent. It would have been presumed in the law for their agent to know the law, for their agent to know how to prepare a deed. If they wanted to have been responsible for preparing that deed, they'd have done it themselves.
But I've just struggled with this case so much because I don't understand why. I can understand a legal description or a meets and bounds kind of problem, that someone would stare at the page and not know that there was a problem. But this is a reservation of mineral rights in a document, and your clients signed it. And so when the question is whether it's reasonably ascertainable that there's a problem, you know, I'm reminded of the case that we just decided about the limestone mining underneath the ground, the Bromley case. You know, when the dishes start to shake in the house because they're blasting under your house, it's reasonably ascertainable that something's happening. And I don't understand why your clients wouldn't have an obligation under the reasonably ascertainable standard to do something, to ask, to go look. And they didn't do anything.
Well, first of all, let me say, because of the court's ruling giving a summary judgment to the other side, my client was deprived of the right to have a trial and put all these facts and all this other information in front of the court so the court could make a decision over all of the facts, not just the presence of deed. You know, the judge, I think editorially added that he thought anybody could figure out that the minerals weren't included in that deed. Well, let me tell you, you may have guessed, I've done this for a long time, and I've done a lot of mineral reservations and deeds. And the one thing that I hear over and over is if somebody is selling minerals, okay, or is buying minerals, I should say, and you give them a deed, and all it is a legal description, and there's nothing in it that says minerals included or this and other, they think you haven't done it right. They think something has to be there to say, oh, the minerals are included. They don't understand the bundle of sticks.
Which makes my point that there was something reasonably ascertainable, and these other people in your hypothetical are holding their hand up and saying, why isn't this stuff here? And then they get an answer.
But we have,
all I'm saying is,
we have the converse here. My client is selling minerals. When you're selling minerals, if you're under that understanding, you wouldn't have a mineral statement. You wouldn't say including the minerals. There were no minerals mentioned, so it was reasonable for my client to think that the minerals weren't included. These are lay people. These are lay people. And besides that,
I think what you're trying to say with your example, you kind of lost me, but I think I've got where you are, that when you sell the whole thing, minerals included, you don't reserve the minerals, you just list the surface.
Right.
And the buyer goes, well, I wanted the minerals with it and you didn't include it. And you're saying that it's not common knowledge for people to know the surface description includes the minerals. That's what you're trying to argue, isn't it?
Absolutely.
Okay.
Absolutely.
You kind of lost me there, but
Sorry.
I think we're back on the same page.
Yeah. No, that's why. Anyhow, I think if the court had given the opportunity to look at the whole picture, like the Court of Appeal says should be done, then the court could understand all of that. And again, my client should not have been put in a position of being the one to decide, is this deed right? That was RCAT's responsibility. My clients did not prepare a deed. RCAT did. And they accepted that they had done their job. And to get to the 2014, they had no reason to suspect otherwise. They continued to get their royalties. The only thing my clients lost was record title. Record title. That's it. They only owned minerals before. They still possessed those minerals. They still acted as if they had the right to continue with the lease with the oil producer, the right to receive the checks. The oil producer paid them regularly.
They paid the taxes. They paid the taxes. They
When
did the internal transactions among
Their name
themselves.
was on the renditions filed with the county, so they continued to pay the taxes over and over. In fact, my clients found out about this after the LLCL deal, when LCL tried to get the oil company to stop paying my client. That oil company said, there's something fishy here. We're not gonna do that. We're just gonna suspend the royalties. And that's what prompted all of this.
Mid-August 2014.
Right, but RCAT had two opportunities. They had the first opportunity to do it right. And then when they examined title on the LCL Sammy Dean transaction, what happened was they didn't notice or didn't understand the transactions that were from my clients to other family members dealing in minerals. If RCAT had believed that my client owned no minerals, that would have been flashed on the title commitment that, hey, there's a stray deed here about these minerals rights. You know, you can't, that didn't happen.
Were there title commitments for those transfers? I thought they were kind of transfers among family members.
No, yeah, I'm sorry. I'm talking about when they saw those transfers and then put them on the title commitment for the LCL deal. Okay. They didn't hit them. And as you suggested, anybody who does anything that has producing minerals, if you're doing title work, the one thing you want to know is, well, it's producing, who's getting the money, and does who's getting the money match who I find out ought to be getting the money? That's an easy check. You go to the treasurer's office and you go to the appraiser's office.
Do I recall that the title insurance identified that lease as being a producing lease?
Yes.
Did the Phalens have the right to transfer their interest after 2008, but before the sale to Dean's in that interim period? Could they have sold their mineral right to someone if they didn't possess it? How would that have worked?
Yeah, well, they could have if somebody was dumb and didn't check title, but I think it would show up if something had happened.
So when the injury occurred is when they would have tried to transfer it, or in 2008 when they didn't receive proper title?
I think you have to talk, there's where you get into this idea of injury and substantial injury. And the loss of record title, especially under the totality of circumstances, clearly was not a substantial injury. Nothing happened to them. They were happy.
Well, it was a substantial injury. It wasn't it? Because your argument is that it's not a reasonably ascertainable injury, or are you arguing both?
Both.
Yeah. If the deed from Dean to LCL LLC had reserved that minerals interest, then your client still wouldn't be harmed. It'd still be getting the minerals interest. It'd still be having full enjoyment.
Right.
It just it'd be oblivious to the fact that the title was messed up there along the way, but they would still have full enjoyment of the property.
They would have, and had RCAT, when they were doing their examination and talking with Sammy Dean and LCL about that transaction, had they done their title work right, and had they notified my client of the mistake, Sammy Dean testified in deposition that if he'd have known that, he would have deeded it back over any time, because he had no claim to it, didn't want anything to do with it. He would have given it back to him. All they had to do was to disclose to our clients what they knew during the LCL transaction. They didn't. They hid it. Not only did they hide it, the evidence would be that they helped LCL structure the transaction so that Sammy Dean, who said, "You're not getting any minerals with this deal," signed the same kind of deed that didn't reserve or say no minerals, so that it was fee title, so that LCL could grab on to my client's mineral rights and do that. Well, and then what happened is LCL decided to get that transfer, and when he couldn't get the royalty, he made a claim against RCAT, or First American Title. And so then they weighed their odds. Which is the better case for us? Fighting LCL on this for giving them a bad title commitment, or sticking it to the Phalens by telling them they are barred by the statute of limitations? Well, and they decided to go to the LCL and pay them. They paid their attorney fees to try to take our minerals away. That's what we've been fighting.
Do we have any further questions of counsel?
One question. The reference a moment ago to whether you're arguing that there either was no substantial injury in 2008, or that whatever substantial injury occurred was not reasonably ascertainable at that time. I just want to get clear in my head what you think our standards of review are on those questions. Is the existence of injury a question of fact? Whether it's substantial enough to qualify for substantial injury in the statutory language, is that a question of law? And then reasonably ascertainable? Where are we here?
Well, the cases that deal with those issues say that when there's a dispute about or conflict in the facts about those issues, it's to be decided by the trier of facts. That's why we should have had a trial here.
Okay, thank you.
Do we have any further questions? Did you need any more time to wrap up, or do you think you've made your points? All right, thank you, counsel, for your candor.
May it please the court. We spent a lot of time discussing the reasonably ascertainable under 60-513 and whether or not the Phalen's injury was reasonably ascertainable in 2008, 2014, and when they suffered injury. But there's another part of 60-513 that I think is very instructive in this case and in Kansas law, and that is subsection 3, where it discusses a cause of action for fraud. And the statute says, an action for relief on the ground of fraud, but the cause of action shall not be deemed to have accrued until the fraud is discovered. This court has repeatedly held that actual knowledge is not required under this subsection, that constructive knowledge imparted by KSA 58-2222 is sufficient to cause the statute of limitations to accrue when the fraud occurred. Not that it's reasonably ascertainable, but that it's discovered. Discovered is a more imposing standard, Your Honors, than reasonably ascertainable. But this court in Black v. Black 100 years ago said that the statute of limitations for 2 years and a cause of action for fraud occurs when the fraudulent conduct occurred. And that's in preparation and the filing of a deed, because the public is charged with constructive notice of what's in that deed.
And do you add to that, as Justice Johnson suggested, then we have to add the next step of, can we presume they know the law and understand what that deed transfer meant?
Yes, Your Honor, and I think you do, because that's what you do in a fraud case. If you were to hold that the Phalens in this case can come in and say, well, we understand that the deed, or we didn't understand the deed, didn't include our mineral interest reservation, you would have that defense in every case based on fraud. that somebody could come in and say, when a deed is filed, I didn't understand what the deed said. I didn't understand the meat and bounds. I didn't understand the legal description. I didn't understand that I was conveying this property. So you basically vitiate the constructive notice created by the statutory law, 582222.
And you vitiate the contract, because we're talking, what happened in 2008 was between the Phalens and Dean. And they had a contract, and they made a deal to sell the land without the minerals, and completed that transaction. They both knew what they were doing, knew what they were paying for, knew what they were getting their money for, and the mistake on the deed basically vitiated the right of two people to contract a deal.
Well, Your Honor, I don't think it's as easy as it just vitiated the contract between the two parties. I think if this court were to hold that the Phalens can come in and say, I didn't understand that I didn't reserve my mineral interest when I looked at this deed. I had 2 days to review it and I signed it. And every other document in this case references reserving the mineral interest, but I didn't understand this deed. That would have opened the Pandora's box in terms of fraud cases and cases in the future where a party's charged with constructive notice of what's the content of the deed or the content, because they're going to be able to come in and say, I didn't understand it. So constructive notice created by the legislature has no purpose.
Well, counsel, the disconnect I'm having, I understand the constructive notice argument, and you're right. It operates as a matter of law to charge a party with knowledge. It's a legal fiction, if you will. But the legislature chose the language reasonably ascertainable in our context. And that's the disconnect I'm having. Reasonably ascertainable suggests to me that it involves a kind of factual totality type analysis of a reasonable person. And can we make that leap from the legal principles of constructive knowledge to what really amounts to a kind of factual inquiry?
And I think you can, Your Honor, and that's why I was talking about subsection 3, where you talk about fraud, or where the statute talks about fraud, and that a cause of action for fraud accrues when the fraud is discovered. And this court, almost over 100 years ago, held in Black v. Black that constructive notice imparted by the filing of a deed is sufficient to start the statute of limitations in a fraud case where it requires actual discovery. Here, you're just talking about an objective standard of whether or not something is reasonably ascertainable.
That actually makes some sense to me when you talk about actual discovery, because now we're talking about what's the legal impact. Whereas I guess I'm asking you to connect the dot to reasonably ascertainable.
And the connection of the dots, Your Honor, is that reasonably ascertainable is a lower standard than actual discovery. And if you look at the language of this court in Black v. Black, the court stated discovery does not necessarily mean until the party complaining had actual notice for constructive notice. It's sufficient to set the statute in motion even though there may be no actual notice. And this is in the context of fraud. And where the means of discovery lies in the public records required by the law to be kept, and which involve the very transaction in hand and the interests of the parties to the litigation, in such case, the public records themselves are sufficient constructive notice to set the statute in motion. That's this court's language in Black v. Black.
But 8 years later in Hutto versus Knowlton, they said, if a fiduciary relationship exists requiring disclosure of the true state of facts, the obligation to search the records is relaxed.
And that's
true. So what do we do? I mean, doesn't that goes back to my question to you earlier, doesn't that offset that constructive notice?
I don't think it does, Your Honor. I don't think it does offset that constructive notice. While the situation may be relaxed, the buttress to that in this case is the fact that the Phalens actually had that deed in their hands for 2 days and had the opportunity to review it. So it's not just a matter of constructive notice imparted by the statute, it's the fact that they had the deed and had the opportunity to review it.
But the pleadings show there's a clear dispute on what happened with that deed in those 2 days. How much they reviewed it, how much they read it, et cetera. I mean, there's a dispute of fact, and that kills summary judgment.
I don't think that kills summary judgment, Your Honor, because the law in Kansas is if a party to a contract, which basically a deed is a contract, if a party fails to read that contract before they sign it, they're charged again with notice of what's in that contract. If the Phalens did or didn't review that deed, they had the opportunity to do so. Whether they chose to do it or not is not dispositive as to my client and whether or not my client sent it to them. They had the opportunity. Whether they chose to or didn't choose to is not negligence on the part of Rice County Abstract and Title. For these reasons, Your Honor, we'd ask that the judgment of the trial court be affirmed.
Do we have any further questions?
I do.
Yes. Counsel?
Yes.
I'm confused. If someone has a document in their hand for 2 days, looks at it and signs it, why are we talking about constructive notice of what that document says when they had it in their hand and looked at it?
Because
Why does that statute have any more force and effect than actual knowledge? Because they had actual knowledge of what the deed said. So why are we talking about constructive knowledge of what the deed said when we have someone with actual knowledge?
Because, Your Honor, and I think, and the disconnect, and it probably goes back to one of the earlier questions in this case is under 60-513, it's a two-part inquiry potentially. The first is did the party have an injury? And if they had suffered an injury, the statute of limitations begins to run from the date of that injury. Or if the injury is not reasonably ascertainable, it begins to run when the injury is reasonably ascertainable. We moved for summary judgment on both of those grounds, that if the Phalens didn't know about the injury because they failed to read the deed.
I understand all of that, but are you saying that constructive notice of what the document said carries more force of law than actual knowledge of what the document says?
No, Your Honor, I think they're on equal footings here. I think it can be either or. You can have actual knowledge of what the document says, or you can have constructive knowledge.
And they had actual knowledge here because they had it in their hands. So what does constructive knowledge have to do with the price of wheat in Kansas right now? I mean, really, because we had actual knowledge.
Fair enough, Your Honor. And if you look at the court's opinion in Bi-State, that's the case that we moved for summary judgment at the trial court level in. Bi-State applied constructive knowledge based on the statute on an easement. And so that was the reason that was an issue. And in that case, basically the Court of Appeals held that it didn't matter if you were an expert at reading easements or whatever, you're charged with constructive notice.
So actually constructive notice gives notice of what the legal effect is what you're saying. They could have actual knowledge of what it says, but once it's recorded, then they're charged with the knowledge of what it means.
Yes.
Is that what you're saying?
That's essentially our argument, Your
All right.
Honor.
Thank you.
Thank you.
Any more questions? Thank you, counsel. Thank you both for your arguments this evening. Court will take this matter under advisement. That concludes our special session at Colby High School. Before I announce our adjournment, I would remind you again, we would love to see you in the Commons area for reception, shake your hand, and visit about many different things. Court is now adjourned. Yeah.